Today's hearing looks at the implications of the Supreme Court's recent ruling in the case of Ashcroft versus Iqbal and its predecessor, Bell Atlantic Corporation versus Twombly. Although the case deals with the liability of federal officials for the post-September 11th roundup of the, quote, usual suspects, unquote, the Iqbal decision has had a far-reaching effect on the rights of litigants in a broad range of cases. Its implications are only now becoming clear, at least to most of us, and the fallout is deeply disturbing. Jerrold Iqbal is a Pakistani national who was picked up in the wake of the September 11th attacks. He was deemed to be an individual of high interest with regard to the investigation of the attacks and was placed in the special housing unit in the Brooklyn and the Federal Detention Center in Brooklyn, New York, which happens to be in my district. He subsequently alleged that he was beaten and denied medical care and that his designation and mistreatment was the result of an unconstitutional determination based on his religion, race, and national origin. The distinguished ranking member, the gentleman from Wisconsin, who was the chairman of the full committee at the time, visited the Brooklyn facility at the time as part of his oversight function, and I joined him in that visit. The allegations were serious then, and with what we all know now, are even more disturbing. When the Supreme Court considered Mr. Iqbal's claim, however, it did not reach the merits of the claim. It did something truly extraordinary. Rather than questioning, as required under Rule 882 of the Rules of Civil Procedure, whether the plaintiff had included a, quote, short and plain statement of the claim showing that the pleader is entitled to relief, unquote, which is what Rule 882 says a claim should contain, it dismissed the case, not on the merits or on the law, but on the bald assertion that the claim, as stated in the pleading, was not, quote, plausible, unquote. In the past, the rule had been, as the Supreme Court stated in Conley versus Gibson 50 years ago, that the pleading rules exist to, quote, give the defendant fair notice of what the claim is and the grounds upon which it rests, close quote, assuming provable facts. Now the court is required that prior to discovery, courts must somehow assess the plausibility of the claim. This rule will reward any defendant who succeeds in concealing evidence of wrongdoing, whether it's government officials who violate people's rights, polluters who poison the drinking water, employers who engage in blatant discrimination, or anyone else who violates the law. Often evidence of wrongdoing is in the hands of the defendants, of the wrongdoers, and the facts necessary to prove a valid claim can only be ascertained through discovery. The Iqbal decision will effectively slam shut the courthouse door on legitimate plaintiffs based on the judge's take on the plausibility of a claim rather than on the actual evidence, which has not been put into court yet or even discovered yet. This is another wholly invented new rule overturning 50 years of precedent designed to close the courthouse doors. This combines with tightened standing rules and cramped readings of existing remedies to implement this conservative court's apparent agenda to deny access to the courts to people victimized by corporate or government misconduct. This is judicial activism at its worst, judicial usurpation of the procedures set forth for amending the federal rules of civil procedure. I plan to introduce legislation with the distinguished gentleman from Georgia, Mr. Johnson, and the distinguished chairman of the full committee to correct this misreading of the rules and to restore the standard followed for the last 50 years since the Supreme Court's decision in Conley. Rights without remedies are no rights at all. There's an ancient maxim in the law that says there is no right without a remedy. Americans must have access to the courts to vindicate their rights, and the concerted attempt by this Supreme Court to narrow the ability of plaintiffs to go into court to vindicate their rights is something that must be reversed. I look forward to the testimony of our distinguished panel of witnesses. I yield back the balance of my time.